Why no state consent is needed for simultaneous elections? What clarification has the Law Commission given? And what are the implications as well as constitutional provisions related to it? India's biggest electoral reform debate has taken a decisive turn where the Law Commission has clearly brought out the fact that states' consent is not required for simultaneous elections. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to discuss what clarification Law Commission has given to the Joint Parliamentary Committee, what are the constitutional provisions around it, and how it impacts the simultaneous elections conversation and debate. So let us begin with understanding what exactly we mean when I talk about or when we mention simultaneous elections. So when we are talking about simultaneous elections as a concept, it basically means that we are going to have Lok Sabha as well as Legislative Assembly elections. That means when we are talking about Lok Sabha and when we are talking about Vidhan Sabha, both of these elections will taking place in sync. Usually you get to see, for example, last Lok Sabha election we saw in 2024. Now, we just saw that Bihar's Legislative Assembly had an election. So, this is where we see elections happening either for Lok Sabha or then for Legislative Assembly of various states. For example, West Bengal Legislative Assembly election is coming up. So, the idea here is that we get this done together, and whenever 5 years are done, then again it is conducted at a simultaneous time. Now, the whole idea, this needs to be brought in, proposed through a constitutional amendment bill so that the intended benefits that we are talking about, simultaneous elections, they can be brought in. What are the intentions behind it? Basically to reduce the frequent election cycles, to reduce the administrative as well as financial burden that comes with the election cycle and the elections, and also improve the governance continuity that exists at not only at the central level but also at the state level. But the whole challenge of doing simultaneous elections lies with the fact that as of now the current electoral cycles are separated, they are staggered due to different dissolution times that are seen for Lok Sabha and the legislative assemblies of different states. So, now that you have understood the idea, what is the concept of simultaneous election, now let us move to understand the next part, that why this debate is coming up to the fore again. So, the idea of simultaneous elections has been proposed for a while now, and as of now this lies with the Joint Parliamentary Committee where they are looking into the drafts bill. Now, when they are looking into the draft bill that will be proposed as the constitutional amendment bill, for better clarity and understanding, Law Commission was brought in, and so that there can be constitutional clarity that how this constitutional amendment should be brought in. Because when we talk about constitutional amendment, there are three ways in which it can take place. Can you tell me in the comment section what are the three ways in terms of majority that I am talking about through which the constitutional amendment can take place? Now, in this very situation, Law Commission has come into the picture. Now, this is where central government is talking about feasibility and the administrative necessity of simultaneous elections. The Election Commission has also supported the idea that it is feasible, but it needs to be done with the safeguards. And the idea as of now is being pitched so that it can be brought in with the next Lok Sabha cycle as well, so that the simultaneous election idea can be implemented. But if it is to be implemented, then it has to go through the procedure of legislation and the constitutional amendment. Now, at this stage, it has not been proposed as a bill. It is prior to that where Law Commission came in to clarify, bring in the constitutional clarity to the Joint Parliamentary Committee. Now, let us understand that what exactly is the clarification that was given by Law Commission to the Parliamentary Committee here. Now, when Law Commission came into the picture, the first thing, major thing that we need to understand, that has been highlighted by Law Commission, that if the constitutional amendment comes into the picture, it does not require ratification by 50% of states. Before I get into the details of it, let us talk about how in 3 majorities constitutional amendment can be brought in. Now, the first one can take place with simple majority. In which more than 50% of members are present and they are voting. The second scenario is of special majority. In this, there should be more than 50% of members present and the majority should be of 2/3 which are present and voting. And the third category in which where there is a simple majority required but plus ratification of more than 50% of states. That means more than half of states, okay, it is special majority plus ratification from the 50% of states. Now, this is where consent of states, the ratification of states comes into the picture, and Law Commission has clarified that this amendment does not need that and it falls under Parliament's exclusive legislative competence. Let me give you examples further to understand this better. When we are talking about simple majority, such as formation of new states can be done through simple majority. But when we are talking about anything that impacts the federal structure, that needs to have special majority with ratification from 50% of states. Law Commission has also clarified that the proposed changes do not disturb the basic structure of the constitution. And the dissolution that we are talking about, that means the house term containment, especially of Vidhan Sabhas, or the extension which will be required to make sure that the simultaneous elections are happening. For example, Bihar elections have just happened in 2025. If we want them to happen again in 2029 in form of simultaneous elections, then this term would be curtailed. And in this situation, Law Commission tells that this is constitutionally permissible as of now, because all of these are not diluting the federalism, rather they are fitting in the model of cooperative federalism. So, this is what Law Commission has told the committee. And when we are talking about this whole scenario, the main component that we need to understand that why or what explanation has been given that the state's consent is not required. So, Law Commission has provided that clarification that as per Article 368 2 proviso, Article 368 specially deals with when we are talking about constitutional amendment and the majority is required for that. So, it says that it requires state ratification only when the amendment is affecting federal distribution of powers, representation of states in parliament, election of president, judiciary's federal aspects and 7th schedule lists. And Law Commission is saying that because it is not related to any of these, what has been provided by Article 368 2 proviso, that is why states' consent is not required, because the only thing simultaneous elections is affecting is the timing of elections. It is not affecting the power, the structure or the representation of states. And Parliament exclusively has the power under Article 246, 324 to 327 to regulate the elections, and that is why we do not need states' consent in this particular matter, and this is constitutionally backed as well. Now, this was the clarification that was given by Law Commission with the proviso which has been provided in the constitution itself. Another thing that needs to be understood, because the Law Commission has clearly brought it out, that it does not affect the basic structure of the constitution, because we know as per the Keshwananda Bharti case, which brought in the basic structure doctrine, that the basic structure of the constitution cannot be altered through the procedures which are provided for constitutional amendment. So Law Commission has gone ahead and also clarified that this does not fall in basic structure, because basic structure elements are usually related to democracy, federalism, free and fair elections. And in this very scenario, we get to see that it is not related to free and fair elections, it is just merely related to tenure of the elections that is taken place, and this tenure adjustment again lie in the prerogative of the parliament itself. So changing schedule of the election is not affecting the spirit of democracy, it is not affecting free and fair elections or the federalism as a structure itself. That is why we can easily get it done through the parliament's legislative process, and there is no concept of states that is required, and it is also not violating basic structure doctrine. What are your thoughts on this? Let me know in the comment section. Also bring in the constitutional provision that you are talking about so as to either stand with the Law Commission's view or against it. You can put it down in the comment section. Now that we have understood two major things that have been brought out, now let us talk a little more about simultaneous elections, because as I said, you can give me your views. Let us understand the both sides that exist, especially in terms of simultaneous elections. So if we talk about simultaneous elections, be it scholars, opposition parties and also states, they have raised some concerns, especially in the context that state autonomy might get weakened with the curtailment as well as extension of the terms that we are talking about. Another thing that had been brought through scholars and also the states, that if the simultaneous elections are taking place, national issues might be brought in front and the regional issues might get diluted or overshadowed in this scenario. Another thing that has been highlighted is the fact that regional parties which are limited to certain states or areas, they will be overpowered by and overshadowed by national parties in multiple dimensions. And also mid-term dissolution of the legislative assembly can become complicated with time. And there is also possibility of, when we are talking about extensions, there can be forced extensions, there can be forced curtailments which can take place, and this is going to affect the spirit of the democracy and also the state elected governments. So all in all, when we are looking just as cons, it is being viewed or it is being pitched as a movement that is bringing the more unitary center, unitary political center, but there are certain prospects associated with it, such as the fact that this will ensure in reduced election expenditure, which will save our tax money. There will be less frequent deployment of security forces as well as staff, which has to be done very regularly because of staggered elections. The policy continuity and stable governance window will be present across the center as well as states, and lesser model code interruptions will take place, and also there will be smoother long-term planning. But Law Commission has given a rebuttal to all of this, where they have clearly made sure that Indian federalism, where they have clearly stated that Indian federalism is not compartmentalized. That means we don't get to see that center is here, state is here, rather they go hand in hand. So if they are talking about going hand in hand, it is based on cooperative federalism, and Constitution also allows for a strong center. So in this scenario, synchronization of elections will only enhance efficiency, will not centralization. On this note, I welcome your thoughts and comments in the comment section. Now I will be leaving you with a practice question here. You can put down your answers in the comment section. The answer of yesterday's question here is D. That was all from my side. Thank you so much.